Friends, as I said, today I'll give you a brief about how Sarat Chandra Judicial Academy trains the candidates, LLB candidates, for the Jcj examination. Though we train you for junior civil judge examination, the same knowledge is applicable to run other examinations like additional district judge examination, EBP examination. You can do it also. First, I want to tell you that generally LLB students, whatever they study during their LLB, same syllabus will be there in the Jcj examination. Nothing much different. However, the orientation in which you prepare for examination is different. The college or university exams you write in LLB or LLM are somewhat different from the exams you write for judge entrance, like Jcj exam. For example, in Jcj specifically, we have prelims, mains, and interview stages, interview, called as viva voice. Okay. Prelims definitely tests few qualities. One is the base subject knowledge, which you cannot avoid. You have to definitely study all the acts mentioned in syllabus, the criminal acts, civil acts. You should learn all those laws. But along with that, out of 100 questions that they give in the prelims examination, as you know, 2 hours, hard questions, hard marks for the prelims, Jcj prelims examination. So, in 100, 70 to 80 questions are purely from the subject. If you are thorough with the books, the laws mentioned in the syllabus, the same books you study for your LLB, if you are thorough with them, you can attempt almost more than 70 questions. However, 20 to 30 questions will be based on the common sense that you get only through observing the court proceedings. Generally, in the moot court competitions that go on in college, you understand little beyond the subject knowledge. You get some common sense. In which cases, how many witnesses are required? For example, how many witnesses required may be there in the books, but it depends on how many moot courts or court proceedings you have heard. Based on that, you get that common sense and experience. So like that, there are 20-30 questions. If you observe the question paper, you can clearly see that 20 to 30% of questions can be answered through such observations in the prelims. And the difference between civil examination and judge examination is that in civil service examination, questions are highly twisted. They give multiple statements. You have to analyze more. But Jcj, you are fortunate that questions are straight away from the books mostly. If you know a law, an act, for example, the Evidence Act, from when did it come into force? Right questions will generally come in the Jcj examination. Okay, so pretty clear and straight. Also, the competition is comparatively very less. You take any other government examination, not only civil services, you take banking examinations, SSC examination, SSC means Staff Selection Commission exam, or any government exam, anybody can write the examination. Competition is very high, but Jcj examination only lawyers have to write. I mean only those who do LLB. You no need to have any kind of law practice to write Jcj. As I told you earlier, previously to write Jcj examination, you need to have a law practice experience of more than 3 years. But as I told you, the recent Supreme Court judgment has made it not mandatory to do law practice to attend the examination. 5-year graduate, just out of LLB, you can write the examination, Jcj. Okay? So hence, the competition is actually very less for Jcj. And let me tell you, most of the LLB graduates do not write Jcj examination, because we know the statistics, no? Very few write. According to me, among all the competitive examinations present around, Jcj examination has least number of candidates applying for the examination, very less competition. Hence, you don't have to think that you have to work extremely hard for the examination. No. If you are smart enough, just do the basic LLB, you can write the examination. Now, coming to the mains exam. Once you qualify the prelims examination, which are hard questions, coming to mains, here is the place where Judicial Academy, like Sarat Chandra Judicial Academy, can really help. Because mains examination, as I told you earlier, the university or college examination and the mains examination of Jcj are quite different. In what way? For example, every student, for example, the question is on domestic violence, let us say. or questions on some evidence that what our question comes in the examination, or they mention some term. Generally in the exam, they give some terms and ask you to interpret the term. In your understanding what the term means. When such questions come, in the university exam, college exam, you have to just mention the meaning of the word, or you have to just define the act, provisions of the act. It's enough. They give you full marks, good amount of marks if you write exactly what is asked. But in these kind of competitive exams, what happens is it's a competition, right? It's a competition. So every student can write almost the same words, because every student who cleared the prelims exam and who go to the mains exam definitely will have knowledge on all the important laws. However, here in this stage, to get more marks, you have to differentiate yourself from others. Your answer should be unique. There should be answer enrichment. Generally, in Selection Judicial Academy also, whenever we finish any topic, any law or act, or finishing, we give some prelims questions for that, MCQs, objective questions. We give some mains questions. Mains means written descriptive. We give both kind of questions. We make you practice. In the prelims MCQs, there is nothing for us to explain. You can write it, you can give the answers. But in the mains, we take separate sessions on how you can make your answer unique. How can you enrich your answer so that you get the extra half mark. Basically in the mains exam you have 3 papers. Civil laws, criminal laws, and third paper is essay and English translation. As you know very well, each paper 100 marks only, 100 marks. Civil laws 100 marks, criminal 100 marks, and the third paper 25 marks for translation, 75 marks for essay writing. Essay writing means not general essay. Essay is also on the legal subject only, legal essay only. But I'll come to the paper later, how essay is different from other questions. Coming to the civil paper, civil law. They give 10 questions, 10 questions will be there. Each question 10 marks, 100 marks, that's all. You will have 10 questions, 100 marks. Now, for getting those 10 marks, if the question is on domestic violence act, the question is about that, okay? You should not only write the provisions of the act, you should definitely mention the recent judgments on the same act. And I am here mentioning recent judgment because friends, as you know very well in India, with judgment to judgment, there will be some variation, there will be progress. For example, the fundamental judgment, the Constitution of India, for example, the initial judgment said that Parliament has no power to amend the Constitution. Later on, after few judgments, they came to a position where Parliament can completely amend the Constitution. If you observe Venugopan's case, Golaknath case, and finally, case on the Bharati case. By the time case on the Bharati case came in 1970s and 73, at the time, the judgment said that Parliament has power to amend the Constitution, but without tweaking the basic structure. It's called doctrine-based structure. So like that, the final judgment is more important. There is no relevance of writing pre-judgment. There is no point also. Final is the most important. That's why I'm telling you, for any act, no need to by heart all judgments, not required. Basically, you should be smart enough to understand the final judgments, the last 1 or 2 cases, the last 1 or 2 judgments, which actually are the benchmark, after which there are no much changes. Such judgments you have to by heart. Remember, read those cases, mention them in the examination. And for mentioning them, you don't need to have full knowledge on the judgment. I'm telling you again, you don't need to have full knowledge. Anybody who thinks that you require full knowledge actually spends more time in any competitive examination, A student who reads in depth, tries to by heart everything, cannot clear. A student who covers the breadth, all cases, important cases, the main few points in the case are enough to quote in the examination. So first, you write about the act, whatever asked in the question. You mention some important cases. Third thing, friends, generally current affairs is not there. The advantage of these exams is current affairs is not there. In any competitive examination of India, current affairs will be there. Where you have read newspapers, current affairs, magazines, whatever. Here, no current affairs. What you study in the LLB is enough. However, though current affairs is not required, though many students do not cover the current affairs, only those students who cover the legal current affairs, means the recent judgments, Supreme Court judgments you observe, High Court only those judgments which you think are very important, which set a trend-setting judgments of High Courts, recent judgments. And I tell you, those students who observe even the small judgment that happened recently and mentioned in the examination, the evaluators, when you evaluate the paper, The evaluator mindset is okay. Now you mentioned judgment, which nobody knows. Very small judgment, not a very major one also, which has not hit the headlines of newspapers also. Minor one. If you mention that, he will feel that here is a student who is not just studying the LLB books, but who is aware of the recent happenings, who is so much interested to understand what is happening judicially. That interest is there, no? That you have to show in the examination. You have to show. Recently also, there is a case on abortion. The Principal Secretary of Health of India versus X has occurred in Supreme Court. So such kind of things you should write, which do not really come in newspapers in the large headlines. So this is the second thing. Third thing is, friends, the space and time are limited. The space and time are limited in the examination. So within less space, less time, writing more dimensions. These are what we will train you. Basically, you may be thinking, Judicial Academy, what additionally do we learn? Obviously, syllabus is same. LLB is enough. Additionally, what do you learn? You learn these kind of things only. We give you questions. We make you practice the questions. We evaluate your answers. We compare your answers with your peer group. We take the best paper where student has made his paper unique. How? Putting some facts, statistics, new judgments, legal current affairs, along with the fundamental concepts. For example, any question has been asked, which relates to Indian economy. It's better you write a small paragraph of Indian economy and then enter the question, not directly enter into the legal question. Such kind of things will help you. This is a stage where it can help you. Then the final stage is voice, which is only 50 marks. 50 marks, otherwise. Mains is 300 marks, 300. While interviews 50 marks. But let me tell you, all the candidates who go to the examination, most of their marks in the mains are very close. There won't be more than 5-6 marks of difference in the final result. There won't much difference. So interview makes all the difference. And interview is something where LLB knowledge is not enough. You should have better interpretation. As you know, in Jcj examination, there is no constitution. In the syllabus of exam, constitution is not there. I think you know no. Constitution of India is not there in the syllabus of Jcj. But in interview, because generally a district judge no need to interpret the constitution. Only High Court just interpret the constitution. That's why syllabus they haven't kept it syllabus. But in the interview, they will test your constitutional knowledge also. I know some candidates, some of our old students, in the mains answers also, they will mention the provisions and articles of constitution. Though question is not direct, the question may be regarding some health. They mention Article 47. The question may be regarding some panchayats. They mention Article 40. The question may be regarding the privacy, whatever. They mention Article 21. They mention Puttu Swami case. Means it's better to add the provisions. Interview is a place where in the 4 months, we actually our course is for 4 months. Sharat Chandra Judicial Academy trains you for the Jcj examination for 4 months actually. It's a 4 months coaching. It's integrated. Prelims, mains, integrated preparation, integrated. Any topic we teach, we give some prelims questions, make you practice them. Some mains questions, make you write those questions. And we tell you the opinions. We take you to judicial proceedings so they can have observation, court observation, which will help in interview. In the mains also to some extent we interview mostly. Moot courts generally will be there. Most of you have moot courts, but our moot courts will be more interesting because the candidates who are with us are preparing for the examination of judge now. So they will be more engaging. Generally in the college, all students may not really engage very well. Some students may engage. But here in the coaching, everybody wants to crack the examination. No? Everyone wants to crack the examination. So the involvement, engagement is at a higher level basically. So through these things, we train you for the Viva Voice interview. I have seen friends personally, some of our students I have seen, have very good knowledge in the law subject. Prelims and mains they score very well. Interview somehow they cannot score. But you can score. Because I spoke to a few seconds, the communication, the confidence, the clarity, we call 3 C's, are very high in you basically. Most of the candidates, though they have very good knowledge, acquired, gained from the books, they can present the examination very well, but they cannot speak it very clearly. They lack the clarity. Or communication may not be so great really. Or calmness may not, whatever. So we have to build those things also. Though it is 50 marks of interview, I will tell you friends, generally the process is transparent. It's transparent examination. If you speak little well, you will get +5, +6, +7, which will completely make you clear the examination. So that is also included preparation at all stages. The reason why the course is 4 months is already prepared for 3 years LLB. You have full knowledge. What we do is we revise it and we focus on the important topics. See, any examination will have some favorite topics. You cannot focus equally in all topics. There are 1000 topics are there. You should not focus equal on 1000 topics. In 1000 there are some 200 topics which are the favorite for the JC examination or which is just more. Your preparation should be proportionate to the focus. In the examination, if most questions come from certain topic, you have to spend more time on that. That is where we can help you. Because in the LLB course, any college have to focus on all areas, no? They cannot focus on few areas. The idea of LLB is to make you aware of all laws. But idea of judicial coaching is to strengthen you in few topics which are important for examination. Understand? So that is there in the coaching. And these 4 months also, for the students who are pursuing LLB final year, or who are pursuing LLM, or who are doing law practice, to make them comfortable, we are conducting evening classes. 5:30 to 8:30 class will happen. So anybody can come. College going students, law practicing candidates, they can come and attend the classes evening. 3 hours per day is enough. Actually 3 months is enough. 4 months is because we conduct weekly exams, topic wise exams, one topic we conduct examination. In a week, what are covered in the week, we conduct examination. Comprehensive exams, we conduct exams basically. That is why it is taking 4 months. Only coaching is 3 months. Overall is 4 months course. And I will tell you, in your mind, though you do not have intention for JCJ, in future you may want to write additional district judge examination or public prosecutor examination, public prosecutor, or when you go to interview to some corporates, you want to join a large corporate which has announced the vacancies for the legal advisors. When you go there, in that interview, you can perform well. So this corporate examination is not just to crack the civil judge examination. The main aim is JCJ examination. But the 4 months of your time, you are spending only 4 months, not 5-6 years. Just 4 months, daily 3 hours only. With these 4 months, you can write a plethora of examinations. Today you may not be interested, but after 1 year, after 2 years, you may have the intention at the examination. It will be useful for you at that time. At that time, useful for you. So, if you prepare now for examination, just 4 months, within next few years, you can write any judge examination, public prosecutor examination. When you go to interviews to any companies as legal advisor, legal team, you can crack that interview very well. So it's an overall thing. Friends, not only Jcj coaching, any competitive examination, for example, engineer, you are writing engineering service examination. With the BTech knowledge, you can write the exam. But it's competitive exam, no? So you need to gain certain more skills. That's why they give coaching. Anything, for example, you are an intermediate student, you read MPC, Maths, Physics, Chemistry, same will be in IIT also. But IIT coaching is to hone the skills, understand the focus areas, become more competent. So, similarly, LLB, same thing is there. But those 4 months will completely fine-tune you. Make you strong in the skills like communication, confidence, answer writing skills, strengthening the focus areas. All the skills will be improved in you. This idea. Okay. Now, I do not know how many of you are aiming for JCJ, but later on, after 5 years of law practice, you can write other judge exam. JCJ is the only judge examination which you can write without any law practice. Any other judge examinations, you need law practice, definitely. For that, extra coaching is not required. As you know, you will be seeing the syllabus, almost same syllabus, same idea. Questions will be more on the law practicing, common sense will be there. That's all. Okay? That's all, friends. I don't want to spend much of your time. I just came here to explain you about Sarath Chandra Judicial Academy. We already have Sarath Chandra IAS Academy, and Sarath Chandra IAS Academy has produced around 109 ranks in civil services. Means IAS, IPS, IRS. We produced 109 ranks in the last 5 years, and we produced more than 90 ranks in APPSC Group 1 examination also. Similarly, we are basically good at training students for competitive examination. But the examinations like this, which has prelims, mains, interview, we specifically focus on such examinations. May it be judicial examination, JCJ examination, may it be UPSC civil services, May it be group 1. Pattern is same. Prelims, mains, interview. Prelims, testing the objective skills. Mains, testing the subjective skills. Interview, testing the clarity, confidence and communication skills. That's all. Basically, it's a game of skills. Knowledge is required, more important, but it's a game of skills. Acquire them, okay? That's all I want to tell you. Yeah.
Just few couple of questions. When is this academy, your judicial academy, got started?
Yeah.
I mean, how many years have you been in this field? And what is the success stories that you could share with us? Maybe name some candidates who have cleared the JCJs, or maybe for the past couple of years, how many candidates have cleared it? Few glimpses of your success stories.
I'm about to tell that. As I told you, Sarat Chandra IAS Academy is there from last 5 years. We produce several ranks. For example, this year found that the 22nd rank, last year Sahitya 24th rank, before that year 14th rank, Yogesh and all students only. Even in the group 1, out of 165 posts vacancies, we got 51 ranks. However, we have started Judicial Academy only few months back, mainly aiming at the students who are actually going to other states for Jcj Coaching. Most of the students of Andhra Pradesh do not have a good Judicial Academy coaching in Andhra Pradesh. They are going out. So we, along with few advocates of High Courts, like Venkatesh, right now practicing our High Courts, Subramaniam, means we have some advocates who are specifically practicing in the tribunals also, and we have some young practitioners who are practicing in the district courts also. And we have selected the advocates in such a way that each of them are expert in a particular sphere of the law. And our faculty are basically advocates who are practicing in High Court, tribunals and district court. The reason why we have kept some members in the team is because the High Court advocates and tribunal advocates will take classes, teach you classes, but we need some people to conduct examination, to make the material for you, to evaluate your papers and to stay with you to clear the doubts. For that we have taken the lawyers who are practicing in the district courts. Hence, Judicial Academy is new. However, the faculty are experienced and we have brought with us the experience of training for civil services and group 1 where we produced more ranks. And I think all of you already know that Sarat Chandra IAS Academy, in fact Andhra Pradesh is the only or biggest IAS Academy. I mean 95% of the ranks from Andhra Pradesh come from our academy only in the last 5 years. I think all of you know about that. But judicial we have started because of these few reasons. Number 1, we have advocate senior faculty. Number 2, we do not want our students to go somewhere far away. We can train here as well. Number 3, our expertise of training in examinations, having prelims, mains, and interview. That's the reason. And thanks for asking the question.
Do you organize the mock interviews also?
Yes.
Like with these mock interviews within the span of 4 months?
Yes. No. Actually, what we do is, again, I want to address also. Friends, mock interviews is something which we conduct for the candidates who are selected in the mains and going for interview. However, like how you said, thanks for that. In these 4 months, we train you not only in the prelims and mains, but also we train you in the interview procedure. We tell you what kind of questions come in interview, and we conduct debates, group discussions, moot courts. We take you to judicial proceedings. We train all those things. However, the full panel mock interviews containing the retired judges. Actually, with our academy, we have a set of retired judges who will not take regular classes, who will take classes only on specific topics, who will give guest lectures, and who will tell you of the examination pattern, but they mostly turn up in the mock interviews. So once you clear the mains examination, in the remaining time, we conduct several mock interviews. However, before writing mains examination, in the 4 months of coaching, we train you to become confident enough to go to the interview. But mock interviews will be there only after the mains examination.
But then these mock interviews exercise is part of the engagement that you do for 4 months, or do you have to enroll separately for mock interviews?
No, they are free. Friends, mock interviews are free for the candidates after writing the mains examination. Till the interviews happen, they are free.
And how about the fee structure, etc.?
Okay. Friends, actually the fee structure is, fee structure depends upon, actually our campus, your classes happen near the bin circle. You can directly see on the Bandar road only, Sarat Chandra There class will happen, and the faculty are senior advocates who are spending their valuable time there. The fees is generally 35,000 per student, 35. But as the first batch of this year, we are giving it for 25,000 rupees. For the first few batches, the fees is 25,000 rupees, including prelims, mains as well as interview in the 4 months. However, after 4 months also, students who can come regularly, generally, the coaching will be over in 4 months. But as you keep coming, you can write exams. To be in touch with the exam process. Every week you can come write a mains exam, prelims exam. I believe the students who write more exams can crack the exam. Not students who have just in-depth knowledge. Knowledge is, as I told you, only to some extent. Practicing more exams, taking feedback. That will be there in after 4 months also. Means we will be there with the person till they crack the examination. And also, an extension to your question, or extension to my answer. If in our students, means those who enroll with us for Jcj Coaching, if somebody wants to write public project examination, they want to write examination in another few months. For them specifically what we do is, JCG exam syllabus is enough, but there will be some few extra topics. For those topics, for that students, we give personal guidance, we give additional material. Similarly, for example, some student wants to attend an interview of some company, basically a legal advisor. The same syllabus will be there, but for that company, they may need expertise of few more topics. That will personally guide them. We are doing it because the reason is, we actually will have very few students. See, this is not civil service group 1 where we have thousands of students. Judge examination, few students will be there. A batch of 50, 60 will be there. So it's easy for us. It's very easy for us to focus on each student. Easy for us to train 3-4 students other examination, because everything is just an addition to JCJ. JCJ is enough. Just addition to it. Any other examination or private examinations, interviews, we help you in that. We, in the sense, among our team of faculty or advocates, there will be few advocates who are good in that subject. We attach you with them, and it's free. We don't charge anything additional. We already enrolled for JCJ, so we don't charge anything extra for such examinations. Sometimes we actually, as I told you, along with the expert advocates, we also have retired judges. As you know, practicing judges or sitting judges, right word, sitting judges should not generally come and take classes. That's why we mostly take retired judges. Means those who are with us, retired judges, and they will help you in mock interviews, and also additional examinations will actually help you. And individual focus will be there because of less strength. Because less strength, individual focus will be there on each candidate. Because some candidates will be strong in writing, but weak in speaking. Some candidates may be weak in criminal laws or something. So we identify that weakness of each student. We sit with them separately. As I told you, in our team, somebody sits with you, strengthen you in those areas. We can understand the weak areas. Generally, a class of 1,000 of things we cannot understand. Class 50, 60 we can easily understand. We pay additional focus, which is not possible in the academies of Delhi, Hyderabad, Chennai. That is not possible, because there students from different states come. Large classrooms will be there. So there is no chance of identifying each student and paying personal attention. Here, basically only Andhra people will be there in Andhra Pradesh. Very few people will write the examination in Andhra Pradesh. And as the classroom strength is very reasonably less, the advantage is that the opportunity we get is, because of less strength, advantage is we can pay personal attention, personal focus, personal mentorship, talk to everybody individually, help you other examinations. That we can do, which cannot be done outside. Actually, thanks a lot for asking questions which are there in many minds, but they might not have asked, and you ask them. Some people will be just waiting for us to ask. For example, he may have some question, he will wait for us to ask, and he has got all such questions, in fact. So friends, I think he got clarity, Kalyan, is there anything you want to add? Sure. Whether Kalyan sir was part of our team, actually he decided to take some mains questions, tell some questions, and write answers for that. But I told him that that may take a lot of time, and already afternoon. That's why I ended it like that. Otherwise, he will tell some laws, acts. Actually, he can tell some laws, acts, case studies, judgments. He actually wanted to tell those things. But I don't think it's required at this point of time. Do you require it?
Why not?
Are you sure? But I think there's time constraint. I think she's very clear at telling that. Okay, friends, it's okay, right? Everyone had something. Hello?
I'm Kalyan Dutt, faculty for Indian Constitution for the students who are preparing for civil service examination. Don't want to drag too much. I will stick to the one point only. Ma'am told to us, ఏదో డెమో లాగా కాకుండా ఏదైనా టాపిక్ కూడా చెప్పండి అని చెప్పారు. సో రీసెంట్గా జరుగుతున్న వన్ ఆన్గోయింగ్ డిబేట్ని కాన్స్టిట్యూషన్ పాయింట్ ఆఫ్లో మాట్లాడదామని బ్రీఫ్ 15 to 10 minutes మ్యాక్సిమం ఫినిష్ చేస్తాను. The debate is regarding marriage rights. Marriage rights. And అందరికీ తెలిసే ఉంటుంది మన సమంత గారి సినిమా ఒకటి వచ్చింది కదా, సినిమాలో మ్యారేజ్ చేసుకుంటాను అని చేసేసుకుని తర్వాత మర్చిపోతారు కదా. ఐ గెస్ ఆంగ్లో సాక్సోన్ పీరియడ్లో కూడా ఇలాంటివి ఉంటూ ఉండేవి అనుకుంటా. సో దే స్టార్టెడ్ టు క్రియేట్ మ్యారేజ్ లాస్. అఫ్ కోర్స్ ఇండియన్ ఏన్షియంట్ పొలిటికల్ థాట్లో కూడా ధార్మిక్ లాస్లో కూడా దే హ్యావ్ మ్యారేజ్ లాస్ వెరీ స్పెసిఫికల్లీ. Well, straight to the point, when marriage laws are framed, but before going to that, sociologists believe marriage is one fundamental institution, they will call social institution, common in all the societies. Interesting to note. Take, let us say, African societies, take, let us say, Asian societies, or go to any oceanic societies, you will find one marriage system. Well, this marriage system doesn't mean universal in all the aspects. There was some period one man can marry 2 wives. There was some period one woman can have 5 husbands. According to period and time and the circumstances, it started to change. Now, every society have their own structure of marriage laws. Well, it was in one of his speeches, it was written in the Panchajanya RSS journal also. He stated, that is Mohan Bhagwat sir stated, there is some kind of homosexual relation in ancient period. This was debated like anything. He is a conservative member speaking about same-sex marriages. This was debated, and one professor, Jawaharlal from Sanskrit universities, he stated he is correct. The evidence is the so-called Jarasandh సమయంలో ఒక ఇద్దరు జర్నల్స్ డింబక అండ్ హంస వీళ్ళిద్దరి రిలేషన్ని ప్రేమిక అనే పదాలతో జస్టిఫై చేయడం జరిగింది. అపార్ట్ ఫ్రమ్ దట్, వెరీ ఇంట్రెస్టింగ్ టు నోట్, సలీం కిబ్వా అనే ఒక ఆథర్ రాసిన సేమ్ సెక్స్ మ్యారేజ్ ఇన్ ఇండియా అనే పుస్తకంలో కూడా హీ డిసైడెడ్ టు సే దేర్ ఆర్ హోమోసెక్సువల్ రిలేషన్స్ ఎగ్జిస్టెడ్ ఇన్ ప్రీవియస్ పీరియడ్. వెల్, దే హ్యావ్ లైఫ్. వీ యాక్సెప్టెడ్ ట్రాన్స్జెండర్స్. ఇన్ ఫ్యాక్ట్, ద ఎంటైర్ మహాభారత్ turned into the next level because of one security. We accepted that. But our society started to witness the colonial lens from the so-called 18th century, after this 1773 Regulation Act and so on and so forth. ఇక్కడ మనం చూసుకోవాల్సింది ఏంటంటే, they started to judge us from the European lens. And there, when their European regions, particularly in UK, they rejected homosexuality as per their religious aspects, and it forced even think about Indian structures. From then, IPC 377 was introduced very interestingly. There is a person, European scholar, wrote a book, Ancient Law. In that book he stated, everything which is against to our system considered to be barbarian practices. So they started to justify something from their lens. You see, there is no time similarities between Kalidas and Shakespeare, but they consider say Kalidas is Indian Shakespeare. No time difference between Napoleon and Samudragupta. They started to say he is Indian Napoleon. They started to judge from their lens. So 377 was introduced to the system. 377 bachgaya, even constitution enforced. The mighty constitution with its enforcement brought political equality and it asked people to bring social equality. The political equality will come from 14, and it started to discriminate from 15, prohibition of discrimination based on gender. Not gender, that is what sex they used. So this 377 still existed. One NGO is there. That NGO, we call it as a NAS Foundation. It works for the welfare of the gays and the so-called HIV patients. This NAS Foundation went to High Court of Delhi. There are some famous judgments of high courts. Recently also we have one. Haryana and Punjab High Court gave IMT Industrial Association versus State of Haryana regarding local reservations. One judgment recently struck down local reservation concept of Haryana government. మనం తెలుసుకోవాల్సింది ఏంటంటే మ్యాథ్స్ ఫౌండేషన్ దగ్గర ఏం జరిగింది? The judges clearly stated 377 is completely violating 14 and 15 and it should be declared as null and void and unconstitutional. And you have doctrine of eclipse. In fact, they won't struck down entire act. There is probably some parts. So they removed this. Interestingly, this 2009 judgment again came to the Supreme Court in 2013. And this time, Supreme Court interestingly reversed the judgment of NAS Foundation. NAS Foundation said, అది కాన్స్టిట్యూషన్కి సంబంధించిన కాన్స్టిట్యూషన్తో పాటుగా లేదు కాబట్టి అది ఉండకూడదని చెప్పిన విషయాన్ని సురేష్ కుమార్ కౌశల్ కేసులో సుప్రీంకోర్టు మార్చేసింది. It said, no. 370 should be there. The court interestingly acted, in my opinion, against the Article 14. This was very much challenging to the many constitutional experts and number of people wrote several articles about Supreme Court opinion. Well, in this period, ఇక్కడ మనకు గ్యాప్ తీసుకోవాలి బికాస్ మళ్ళీ ఈ కేసుపై జడ్జిమెంట్ అనేది డైరెక్ట్గా రాలేదు, చాలా విషయాలతో కనెక్ట్ అయి ఉంటుంది. అందులో మొట్టమొదటిది కేఎస్ పుట్టస్వామి జడ్జిమెంట్. వాట్ కేఎస్ పుట్టస్వామి జడ్జిమెంట్ సేస్? కేఎస్ పుట్టస్వామి జడ్జిమెంట్, I just remember the words of Justice D.V. Chandrachud. He is a justice at that time, now CJI. He says beautifully, the idea of liberty for all of us is not only from the external absence of restrictions, it even includes absence of internal restrictions. It is the persons who will have their liberty, and according to the Universal Human Rights Declaration, they used to have even privacy. So let us make that privacy. In his writings, he continued to say, and then we have Article 21, the vast judgment of Keshavananda Bharati stated, Article 21 even includes right to privacy in case of some. See, one article, when I discussed to my constitutional students, this one article has several judgments. 121, for example, MC Mehta versus Union of India, right to environment. When people are debating about Delhi pollution, I said Subhash Kumar versus State of Bihar, right to pollution-free water, pollution-free air. When people say some people are not able to educate well, they are backward because of lack of schools, I said it is Mohini Jain versus State of Andhra Pradesh 1993, right to education. It's part of Article 21. And it included now case Puttaswamy versus Union of India stated you have privacy too. Interestingly, my dear friends, now things got U-turns, not single U-turn, triple U-turns. Because now some people got very interesting questions. What comes under privacy? What comes under privacy? There is a Nelsa versus Union of India judgment which says you have a right to decide about your gender. It is your privacy. Let us say it seems to be like a man, but I want to be a woman. Let us say you can choose. It's your privacy. And this Nelsa versus Union of India made Indians to recognize the third gender, that is your transgender. See, I told you secondly, we accepted previously, but recently even Telangana High Court also struck down the Eunuch Act 1990 in Telangana. Act ఏం చెప్తుందంటే హిజ్రాలు ఒక చోట ఎక్కడన్నా సరే డాన్స్ వేస్తూ కనిపించినా సరే వాళ్ళు అరెస్ట్ చేయొచ్చు. ఒక చోట ఎక్కడ రేప్ జరిగినా ఏదైనా ఒక ఇమ్మోరల్ ఇన్సిడెంట్ ముందు వాళ్ళని అనుమతిలో అరెస్ట్ చేయొచ్చు. The act was struck down. Till now, we started to treat them in a different manner. So finally, what is important, my dear friends, in this NASA judgment, Supreme Court accepted this third gender. Now, I told you there is one more U-turn, and that U-turn is going to now happen. That is one cinematographer, Navtesh Singh Johar, he went to Supreme Court and said, 377 is violating Constitution. It's a review petition, in fact. So Article 137 says you can file a review petition against Supreme Court once again. It allows. Finally, Supreme Court interpreted in manner that it says 377 is unconstitutional and it allow people to have so-called same-sex relations. This is a beginning for next debate in the Supreme Court marriage rights. Why? We have Hindu Marriage Act. We have a Marriage Act for Christians, even Parsis, even Muslims too. Sharia, in fact, 1937. They all allows marriage as per their religious points of view, as per their cultures and traditions. Question personal, absolutely. But the question comes is where these people, these relations will be authorized or can be accepted by the government. So they started debates about marriage laws, and this LGBT community came in front and they started to debate. There is pride revolutions. They started in Bangalore, Delhi, pride movements they started to do. ఈ సమయంలో వచ్చిన సంబంధం లేని జడ్జిమెంట్ చెప్తాను మీకు. అస్సలు ఈ విషయానికి సంబంధం లేని జడ్జిమెంట్ అదేంటంటే, హాదియా అనే ఒక పర్సన్, వాళ్ళ నాన్నగారి పేరు అశోక్, ఇంట్లోంచి వెళ్ళిపోయింది అమ్మాయి ఇంట్లోంచి వెళ్ళిపోయే సమయం 16-17 వయసులో వెళ్ళిపోయింది. వెళ్ళిపోయిన అమ్మాయి కిడ్నాప్ కేసు పెట్టడం జరిగిందంత. బట్ ఆ అమ్మాయి కొంతకాలానికి బయటకు వచ్చింది, తన పేరు మార్చుకుంది, హాదియా అని చెప్తుంది. అంతకుముందు పేరు అలేఖ్య. ఈ అమ్మాయి ఏం చెప్పిందంటే నా పెళ్లి నా ఇష్టం అని చెప్పింది. షీ వాజ్ మేజర్ అట్ దట్ టైం కన్సిడర్ టు బి. వాళ్ళ అశోక్ అని వాళ్ళ నాన్నగారు ఏమంటారంటే ఆ అమ్మాయిని బ్రెయిన్ వాష్ చేసి ముస్లిమ్స్గా మార్చేశారు. అట్ దట్ టైం ఇట్ ఇస్ ద ఫస్ట్ కేస్ ట్విట్టర్ షేర్డ్ విత్ హ్యాష్‌ట్యాగ్ లవ్ జిహాదీ. Now Alekhya became Hadia, but father said no. Father went to court. Where is my daughter? Father, unable to satisfy with the High Court judgment of Kerala, and he went to Supreme Court. This case, very interesting to know. Very interesting, I will tell you. Case has moral and legal aspects. Our society says, the father has to do Kanyada for his, satisfaction of his grahasthasrama. Opposite side, they are saying Article 14, Article 15. Why you are treating this girl, major girl? So when a major boy is doing marriage, you don't speak anything. Now, debate enter into 21. This time, the judgment, when I teach this judgment to students, I will be very careful. Why? Judgment says, right to marriage comes under 21 and personal liberty. Nobody should interfere. I told you the words of liberty, absence of restrictions, externally and internally. Right to marriage comes under Article 21. In this case, the case went to the next level within few months. Hadia judgment వచ్చిన కొన్ని నెలలకి ఇంకొక ఇంట్రెస్టింగ్ జడ్జ్మెంట్ జరుగుతుంది. శక్తి వాహిని అని ఒక అమ్మాయి హర్యానాలో పెళ్లి చేసుకుంది. ఆ పెళ్లి కులాంతర కావాలి. ఆ పెళ్లిని లోకల్గా ఉన్న పంచాయతీ ఉంది, వాళ్ళు దాన్ని కాపు పంచాయతీ అంటారు. ఆ పెళ్లిని వాళ్ళు తిరస్కరించారు. అమ్మాయి సుప్రీం కోర్టు. ఈ జడ్జిమెంట్ ఇంకా పవర్ఫుల్ ఉంటుంది. నో ఎక్స్టర్నల్ పర్సన్స్ ఇంక్లూడింగ్ ఫ్యామిలీ, పేరెంట్స్ అండ్ సొసైటీ హ్యాస్ ఎ సే ఆన్ అడల్ట్ మ్యారేజెస్. Now two judgments saying one thing commonly: right to marriage is a personal liberty choice. With whom they are marrying, with whom they are going to have a life, it's irrespective to you. Means society, parents also. Judgment says very extremist words. This doesn't debated among our community much, but this debated among LGBTs. What Supreme Court says? You can marry on your wish because it comes under 21. Now point is, we have personal liberty. Then these people started to marry. The first marriage in Telangana happened to Supriyo Chakrabarti, a hotel management professor in fact, which I met him once after marriage in fact. The words I spoke with Supriyo, today he is interested to call him as a Supriya. Okay, we should not laugh please. Okay, Supriyo Chakrabarti says, marriage is my choice as per Supreme Court only. I am marrying. I know from he married a Punjabi person, Abhay Dhang. He says, I want to marry this fellow. I married it. I said, okay, but how can you get all the benefits? Because marriage is in India is essential for many things. Your partner will be a nominee for you. Let us say you are infertile, you can get a surrogacy last year. You infertile marriage for 5 years. Nainitara faces situations here. Nainitara married, within few months he started to post images of twins. People got shocked. What is this? So, because Surrogacy Act says 5 years proved infertility. So, for surrogacy you need marriage. According to CARA, that is the Central Adoption Resource Authority, you need adoption, you need marriage. That too, the definition goes like this. That is, you should have what is called heterosexual couple should be there in CARA. These people got troubles. Insurance రాదు, హెల్త్ ఇన్సూరెన్స్ తీసుకోలేరు, లేదు లెట్ us say అడాప్షన్ రైట్స్ లేవు, సరోగసీ రాదు. This person even not, the marriage is even not recognized. I told you with Samantha, the story of Dushyanta and Samantha. Marriage not recognized. Later he realized, oh, I married you. Then he came to know. Shakuntala, I guess so. I want to confirm here, what happened to Samantha should not happen to anyone. That is where they went to Supreme Court. This time they failed. They asked. I told you Hindu Marriage Act, Christian Marriage Act, and then passes. There is one more act, Special Marriage Act 1955. The act goes like this. Interfaith and interreligious couple, intercaste couple can marry. But you should have a process. The process is, you have to go to register, you have to apply, so on so person. Then the process will start 30 days, they will wait for the, in any objections, no objections they will go. But our today's generation, instant noodles, instant biryani generation, they don't take such stuff. 30 days is very used. So they will take one Venkata Babu photo and they will start Pelli Mantralu. If they love Muslims means they will start thinking Christians, their other music will go and they will marry. I mean, just kidding. Even I am seeing many things. So some special marriage act is there. Who will wait for 30 days, sir? They will kill us. So we will go for this option only. Instant students, we cannot do anything. So friends, I want to confirm. He went to Supreme Court and he asked one question. Recognize our marriage under Special Marriage Act. Interfaith, intercaste, but this is very unique one. Supreme Court established a 5 judges bench. You know, something is very important in constitutional interpretation. 5 judges are minimum, according to Article 145. 5 judges bench was constituted. The bench name itself, Supriyo Chakrabarti versus Union of India. 1 year, arguments went for 1 year almost. Not exactly days, but still. 2022 case file. Hardly 2 months back judgments came. Judgments goes to 3:2 and says, we cannot recognize your marriage under Special Marriage Act. We don't, because we are not, I was shocked to see that interpretation in fact. Any interpretation beyond our limitation is going to violate special separation of powers. For the first time, even I shocked to see. Antamundu NJSC judgment vachinappudu they entered into a separation of powers, they struck down without any concern. But this time they say, no, we are concerned about special separation of powers, we don't want to enter them. And it asked the government to form a committee under cabinet secretary. This ends with one more thing, that is adoption rights. Court says, we are agreeing with you, but we are not able to support it because the 2 judges are minority. Interestingly, CJ even minority at that time. So, in the short span of 10 minutes, I just explained you the pain and traveling story of LGBT community. Okay, whether you accept or not, many sociologist documents are writing pros and cons. Even Indian society is saying it is only limited to only urban areas, not to village areas. But still, one thing is important. It is the constitution which we framed in 26 January 1915, enforced in 1950. Constitution gives us one important thing, that is liberty. Preamble says liberty of thought, liberty of expression, liberty of belief, liberty of worship. Why can't we accept them as a part of liberty of thought and expression? Accepting may create some kind of challenges to the society, but it is not going to create any kind of disorder and public order. These are not my words, words given by even Honorable Supreme Court itself. So I want to conclude by saying one thing. There is one judgment, that is Genova witness case. One of my favorite judge, Chinnappa Reddy, write these lines. Our history teaches tolerance. Our philosophy preaches tolerance. Our constitution practices tolerance. Let us not dilute it. Thank you so much.